is a technology. One level of control is technology-based limits, and the other are water quality-based limits. So the technology side is where EPA looks at a national scope of different industries and industry subsectors and identifies a level of pollution reduction that is the best available technology economically achievable. And permit writers, when they get an application, they identify a permittee's industry that they belong to, and then look to see what national technology limits apply, and develop effluent limits for that facility based on those technology guidelines. And then the second piece is our water quality program, where we look at the level of protection that's required in order for the receiving water, whether it's the stream or lake or river, requires in order to meet its designated uses, such as supporting a healthy sports fishing population, or primary contact such as swimming and boating and that sort of thing. So under the technology approach and water quality approach, we develop limits for facilities that propose to discharge to waters of the United States. Another key background is that the Clean Water Act sets up a framework for EPA to have oversight of the NPDES permitting program, but for states, territories, and tribes to apply for primary authorization of the NPDES program, where EPA approves that authorization package and then takes on a more oversight role. So currently, 47 states and the U.S. Virgin Islands have the primary permitting authority, and EPA regional offices have an oversight role framework within that. But the states of Massachusetts, New Hampshire, and New Mexico are the only 3 states that remain where EPA issues the NPDES permits. So that is EPA's Region 6 office for New Mexico, based out of Dallas, and then EPA Region 1's office in Boston issues the NPDES permits for New Hampshire and Massachusetts. So with that background, the topic of today's call is a proposed rule and final rulemaking effort that we're doing in the NPDES program, which is the NPDES application and program updates, final rule phase 1. And so on May 18th of 2016, EPA proposed a rulemaking to update the NPDES regulations to eliminate certain regulatory and application form inconsistencies, improve permit documentation, transparency, and oversight, clarify some existing regulations, and then basically clean up the regulations and delete some outdated provisions that were no longer applicable. And so that notice on May 18, 2016 proposed some targeted changes to several different sections of our NPDES regulations in Chapter 40 of the Code of Federal Regulations. Part 122, we proposed changes to some definitions, permit application requirements, and then other provisions for water quality-based limit development and documentation. In 40 CFR, the CFR is the Code of Federal Regulations, we proposed changes to Part 123 and EPA's ability to object to certain proposed state permits. And that's part of EPA's oversight responsibility. In Part 124, we proposed changes to public notice, and I'll talk more about these provisions a little bit later. Things such as 401 certification procedures, and I can provide some detail on that as well, and other requirements. And in Part 125, this is where we identified an outdated reference to something that no longer was applicable, and we proposed deleting that. When the 75-day public comment period closed in the summer of 2016, we had received over 14,000 public comments from states, environmental groups, citizens, municipalities, industrial stakeholders. And that included over 450 unique letters, comments from 26 different states, and 8 mass mailing campaigns that came up to over 14,400 public comments themselves. And because we were tackling some application requirements in our proposed rule, we decided this would be a good time to update EPA's application forms for the NPDES permitting program. Some of the forms pretty much haven't been updated since the late 1980s, and I think the most recent updated form happened a good 10 years ago. Don't quote me on that, but so we thought this would be a good opportunity to clean up our application forms, streamline them, provide better instructions, clarify things that have caused receipt of incomplete permit applications in the past, and just do a general overhaul to the application forms to make them cleaner, easier to understand, and easier to fill out. So fast forward to the fall of 2018, EPA indicated that several provisions of the proposed rule would be split into at least 2 final rule actions. There were several of the provisions in the proposal that garnered a lot of the public interest and comment that we just have decided that in terms of resources, we would have time to address them at that later date, but right now what we could get out the door are some of the easier, less controversial items that we proposed in 2016. And we do anticipate for those provisions that didn't receive too much in the way of public comment to be finalized this December. So we're nearing that date, and because the package, as I mentioned, is not final and neither has it been signed by the EPA administrator, I can't provide any guarantees on what would be in the rule, but I can, for informational purposes, say what I anticipate to be in the final rule. And these would be minor, mostly clarifying revisions to the NPDES regulations, modernizing the way that permitting authorities can provide public notice of a permitting action, and updating some of the application requirements, and as I mentioned separately, updating the NPDES application forms. So to give you a flavor of the provisions that are in the final rule that we anticipate happening, though I can't say I can guarantee them, are updating EPA's contact information in the Code of Federal Regulations. Right now, it lists a website that we jettisoned a couple of years ago after updating our EPA's whole website platform, as well as the telephone number and address of the NPDES permitting program. A couple of updates to clarify in the definitions what is a pesticide discharge. Another correction is just simply correcting a typographical error in one of the definitions that's been in the regulations for quite some time. And then we also anticipate in this final rule to clarify application requirements. So these are minor things like, for the first time in EPA's applications, asking for a permittee's email address. Trying to get up to the 21st century here, albeit slowly. So we would be asking for email addresses for the first time. And then, as I mentioned, just sort of reformatting the forms to improve usability, create sort of a sleeker format, and improving the application form instructions so that they are easier to follow for an applicant. We also, we're going to update some contact information and references to old databases that have not been in use for some time, and provide a correct and updated database address for any issuing party to find guidance documents on EPA's website. Another big thing that was important to permitting authorities, an anticipated change to how permitting authorities can issue public notice. So right now, when the regulations were first developed, issuing a public notice of a permit for public comment was deemed, the best place for that to be in newspapers. And now that we're, it's the year 2018, we anticipate providing the option for permitting authorities to post certain permitting actions for public notice on a publicly available website. And that would reduce costs to permitting authorities, as publication in newspapers is not the cheapest way to do things anymore. And so finally, one of the other revisions is that we anticipate is deleting a provision that was applicable to publicly owned treatment works covered under the NPDES program. So the statutory provision that supported that regulation was repealed in 1981, although it still appears in our regulations, although it doesn't have much effect. We would be deleting that provision. So that is the general flavor of what we anticipate updating in the next couple of months. I can stop and take questions here before I just elaborate on what else was in the proposed rule that we're just not addressing at this time and we anticipate addressing at a later date.
Anyone have questions?
Yeah, this is Lloyd Kirk. Can you hear me okay?
Yes.
Yeah, and I'm in Oklahoma, Region 6. And in regards to produced water, are you working any on that committee?
Produced water?
Yeah, produced water discharge into streams and
no. To the extent that someone is, I haven't been involved, no.
Right. Because there's some proposed, we're trying to get delegation from EPA Region 6 for NPDES permits or discharge into streams.
So Lloyd, what is produced water?
Produced water is in the oil and gas industry, and currently we do not have delegation, even though we have delegation, we have authority for everything else on NPDES permits. It goes to the Corporation Commission, and they work with EPA. But we passed statute last year to delegated authority of the science work. They classify it as a deleterious substance under their rules. And mainly it's the water that's produced after they frack a well. And it flows back. You have flow back. Most oil and gas companies recycle most of it, but they still have some water they dispose of.
What I can say is that anything on produced water or flow back wasn't within the scope of the proposed rule and isn't in the scope of this final rule. I have heard like read news articles about produced water and know that it's an issue within the oil and gas industry, but I can't comment.
Right, correct. Right. And just an FYI for the group, that was one of the main reasons for a lot of the earthquakes, because of the disposal of produced water in wells in Oklahoma and other states, causing earthquakes in Ohio, Pennsylvania, you name it, all the different states. Now New Mexico and Texas. So it's a big issue in the energy producing states. But thanks. I just wondered if you were had any more information on that. So thank you.
Yep, welcome.
Anyone else? Otherwise, I guess Frank, you can go on.
Okay, sure. So if anyone, I'll just touch on sort of the last piece, which is let me just bring up my note. So in the proposed rule, back in 2016, I meant that there were other provisions that garnered a lot of the public interest, and that in terms of resources, we decided that we would not address those at this time, and instead address them in a later rulemaking. And so I just wanted to note that some of those things, what those things were. One was the definition of proposed permit, and that ties into the objection of administratively continued permits. And without bogging down too much into the weeds, what that means is we had proposed changing what the definition of proposed permit meant to include permits that had been administratively continued for a long period of time. And what that means is once a permittee has a permit, and typically the permit term is 5 years long, if they apply for a new permit before within 6 months of the expiration of their current permit, their current permit can be administratively continued essentially indefinitely until the permanent authority gets around to processing the application for the renewed permit. So it doesn't penalize a discharger for the fault of the permanent authority taking such a long time to process their application for a permit renewal. So as long as a facility gets their new application in at least 6 months before their old permit expires, they can be covered under their existing permit until the permanent authority processes that application and issues a new permit. And so what EPA had found, I think, in the proposal, and I will note I wasn't part of developing the proposal, so I don't have concrete facts, but some permits were administratively continued for 5, 7, 10 years even. And I think that the issue for the proposal was that in certain cases where there's issues of water quality and they're not being addressed by renewed permits, EPA could object to those very long-term administratively continued permits and then provide comment on them, in which case it would sort of spur the permanent authority to issue the new permit. So we're not addressing that right now. There's also other requirements that seem to garner some public interest. One was requiring a lot more documentation in the permit and permit fact sheet itself as to how the limits were calculated for each permit, and then other minor changes, including using different levels of flow to develop permit limits, references to a provision called anti-degradation, which prevents degradation of water body and their water quality. Just other parts of the NPDES program. And so we do anticipate at some future undetermined time to address those, but they are just not part of this final rulemaking action that we anticipate to close out to the end of December 2018. Are there other pieces of the NPDES program that I could, if I'm able to, just provide some background on? I recognize that as someone earlier said, they're not super familiar with wastewater permits.
Frank, we deal a lot with different kinds of businesses, some of which are subject to categorical standards.
Yeah,
so
okay.
I don't know if the new NPDES changes will affect how pre-treatment permits are issued and how those limits are set, or whether some of the categorical standards will be changed.
Yep, so any changes to how the permits are issued or changes to categorical pre-treatment standards, those were not within the scope of this rule. So so the answer would be no. In terms of this rulemaking, those would not be changing. So as I did mention, we do anticipate having changes to our application forms. And so to the extent that any permittee, whether they are a discharger discharging directly to a water body or an indirect discharger, a categorical industrial user sending their wastewater to a POTW, the applications for everyone would be sort of refreshed and renewed. But in terms of the process and what standards apply, that wouldn't change.
Now, are any of these driven by water quality standards being changed or changing? I know in the air world, they determine what is air quality standards, and then they write rules to try to help meet those standards. And usually the states have to come up with a plan to help meet those standards. Are there changing water quality standards which might require more stringent permitting in the future? Because I know EPA has, or there's a generic rule, is at least as far as discharges to a POTW, no interference and no pass-through. So I don't know if based on current issues or potential issues or with water quality standards dropping, that might require, a different or a more stringent permit in order to achieve water quality standards.
Yeah, so I'll say two quick things. So the short and sweet answer is that none of that, what you just mentioned, is within the scope of this rulemaking. So no, none of that would change. And just for more background, I think this is where the Clean Water Act and the NPDES permitting program differs from how air permits and air quality standards are generated. And I know little and less about the air program, but from what you just described, it sounds like EPA sets national ambient air quality standards, and then states sort of implement that. In terms of the NPDES program, states are in charge of water quality standards, and they are subject to EPA review and approval. So what the water quality standard is that applies is generally, that's a state-driven thing. And then the permit writers, whether they're from EPA, if it's a state that does not have the NPDES permitting program authorized for it, or the state is authorized and they issue their own NPDES permitting permits, then the permit writers would just take whatever water quality standard is applicable and then derive limits from there. But so none of that is part of the scope of this rule. But the standards themselves, that's actually a state-driven thing, and it's just subject to EPA review and approval.
As far as the water program, do you have focus groups for any particular industry sectors? So I know in Indiana, metal finishing is a big sector, electroplating, and there's a categorical standard. So do you ever identify issues with particular industry sectors where, it would be beneficial to meet with some of the representatives from those sectors? And I don't know if you recall, back about almost 20 years ago, there was an initiative called the Common Sense Initiative, or the Strategic Goals Program, that worked with the metal finishing industry. And I think part of it was looking at different initiatives, one of which was sampling requirements. There was EPA sampling requirements, and then the state might require more samples to be taken, and then the cities might require more samples to be taken. The fear being that something gets inadvertently put down the drain that might cause an upset or a pass-through. So I don't know if EPA has worked with an industry sector to address any current issues that might impact their operations.
So again, I will answer in two parts. One is that so none of that was in the scope of this rulemaking, and two is that one of our sister programs, which is in EPA's Office of Water, within the Office of Science and Technology, the Engineering and Analysis Division, they are the group that evaluates different industries and industry subsectors, like the metal finishing industry, for example. And they're the ones that review the technology standards that apply to that industry category.
Okay.
And I think, again, I know a little, but not much about their program. But I know that there's a continuing planning process that they go through every couple of years. It might be every 2 or 3 years, where they list the different industry and industry subsectors that they plan on either evaluating or reaching out to, and in terms of either revising or making changes to the technology standards that apply to that industry category.
Would you happen to
go ahead. I'm sorry.
Would you happen to have a contact for someone in that group that maybe we could reach out to? And I don't know if they would be willing to talk to us about this planning process or what the results are of this planning process.
Sure. I can send that to you. I can send you a contact after the call.
Again, a lot of times, well, like I said, jack of all trades, master of none, which basically means rely a lot on people like yourself to kind of fill in, at least maybe to make us more than just dangerous with knowledge, but at least semi-knowledgeable, and at least be able to direct people where in areas where we need to direct them. And admittedly, it's been a weak area for me as far as NPDES permitting. And actually, I was thinking, I was trying to work with one business that is meeting it. They're a metal finisher, and they have a NPDES permit to discharge to a city. But apparently, the city is required to do some toxicity testing, where they immerse certain fish in a mixture of the effluent and the stream from the city's discharge. And depending on how well those fish survive, means that maybe they're not meeting a limit, and it may impact their one of their users. So I don't know if that drives. It seems like then other factors can trump even the categorical limits as well.
Mm-hmm.
So and I take it this isn't going to, the new rules won't affect how POTWs might have to develop more stringent standards than what the categorical limits might require.
You are correct. Yeah, that's outside the scope of the particular rulemaking that I discussed today. Yeah.
Now, do you know if any of this, improvements to modernize maybe the way applications are made, is anything being done where it's going to be done electronically, where someone?
Yeah, I think I can say that we're exploring that. We recognize that sort of like even something that would be as cool for my just personal view as like a TurboTax for permit applications. There's some talk of just kind of upgrading our applications and how they're processed. Right now what we have is PDF fill and print.
Right. Yeah.
But an electronic system is something that I think is interesting. I know that I think the state of Nevada has an electronic permit application system, and so there are some models out there that EPA can look at. And I would just say that would be coming down the road.
Okay. Future.
Yeah, sometime in the future might happen.
Now, do any of these changes affect the stormwater permitting?
No, just in the idea that again the stormwater permit, or there's certain application forms that are specific to stormwater, and as part of the sort of revising the whole suite of application forms, the application form will be updated a little bit with improved instructions and format, but nothing would change in terms of how the permit is processed.
Now, the new rules tentatively going to be, or you anticipate it being signed in December.
Mm-hmm.
I assume then it'll have to go through a certain period of time for comment.
So it went out for public comment back in the summer of 2016, and it is currently with the Federal Office of Management and Budget for review. And then we'll get the Office of Management and Budget's comments back as part of the rulemaking process, and then finalize, the final version of the rule, and then have it signed.
Oh, okay. So it'd be a final. It would come out final then.
Yeah. Mm-hmm.
And so after that rule, then you would be working on making updates to the application forms and other components you anticipate will be in the rule.
Yeah. So the final rule, I'll say the draft of the rule that is with OMB includes what we anticipate finalizing, and this is the Office of Management and Budget's time to review what we've put forth as the final version. We'll take their comments and then address them, and then yes, what we get back will be what what is signed by the administrator will be the final regulatory revisions that will be made upon whatever the effective date is of the rule, which is usually anywhere between like 30 and 90 days after the date that the rule is signed by the administrator. And as part of the proposed rule in 2016, we did in a separate docket put what the new application forms would look like for folks to comment on them.
Oh, okay.
So we got very, very minor comments as people looked at those draft forms as well. And so then there's another round of the Office of Management and Budget review where they review the new application forms. And we can't use those forms until they approve them. That's they meaning OMB. And so that sort of happens sort of in parallel with them looking at the final rule and providing any comments on that.
Now, just trying to get a better grasp or handle on forms, how many people would be potentially affected by, that is, or have to use these forms? We're talking like 10,000 or 100,000, or is it a very select group?
So it's eventually it's pretty much everyone that requires an NPDES permit might be affected. So I'll just say the plug here is that generally with any rule revision that EPA makes, states are then required, if they are authorized to have the NPDES program, they're required to make conforming changes, and they have 1 year after the date of EPA's rule to make those changes if they have to do it through regulation, and they have up to 2 years to make those changes if it requires change by their by state statute or through their legislature. And so states who have the program, the primary authority to run the NPDES program, their application forms for permits that they issue have to collect, at least, the minimum of what EPA requires.
Okay.
So in some form, in one way or another, all states would be required at some point to update their application forms.
Okay.
But they also have the choice, if they don't want to create a new form, they could just use EPA's updated form. And we, our regional offices will be reaching out to work with the states about updating their application forms once the rule is finalized and we know exactly what will be in the rule and what changes will be made to the application forms. Once that's all finalized, we'll be working with the other permitting authorities that are run by the states about updating the application forms.
Now, I know you mentioned that the future, as far as electronic submittal of applications was, again, future. But with that being said, you mentioned there is a PDF fill. Can you do a PDF fill and email, or would that be up to the individual states as to whether they would accept that as far as an application submittal?
Yeah, that's a good question, and I don't know the specific answer. I think that most application forms that EPA gets are generally PDF filled. I think they're printed for signature, and then I think typically they're scanned back in and sent via email. But I don't know that that's definitely the case. And I just can't speak to the different state permitting programs and how they accept permits.
So you would accept, the EPA would accept a scanned copy as far as the signatory.
I think so. Again, I can't put a specific yes or no on that.
Oh, okay. Well, I know we have in Indiana and many states with NPDES discharge monitoring reports, there was a process where you had to have an authorized person, and they had to become registered in order to be able to make those submittals electronically. So I didn't know if before someone could turn in an application, they also had to have some authorization that was granted through some process, but maybe not. So I know I seem to be hogging the conversation. There's got to be someone else who has questions. Frank, you mentioned you'd be working, or EPA would be working with the states. Do you currently have some type of ongoing conversation with the states about these changes coming up and whether certain states are in the process of, well, I guess they have to wait until the rule becomes final before they go through the process of adopting them, but at least finalizing any last minute issues with any of the semi-final forms that you would be using for NPDES applications?
Yeah, so after the proposed rule closed for public comment in August of 2016, there were several, I guess we would call them meetings, discussions that EPA had with the Association of Clean Water Administrators, who represents the state Clean Water Act implementation programs. And we had, I'd say, about a dozen webinars with representatives from the state NPDES permitting programs about the approach to the final rule, taking their, just kind of discussing the process and the different provisions and taking clarifying questions. So we've been in touch, and we also had at least one call this year to just keep them apprised of the process and where we were. and letting the state association know and any state members that joined the call that we were dividing the provisions in the proposed rule into at least 2 phases, one being what we're anticipating finalizing this December, and then the other chunk at a later date. And we also put out for public notice recently an information collection request for public comment, which included how much money we anticipate the rule that will be finalized in December saving. Certainly it's draft because the rule is not finalized yet, and it makes it, just certain assumptions. But with that information collection request public notice, we put out we put out the revised application forms again for public comment, and we did get a comment from one state that looked through the forms again and identified just a couple of minor things. So states, I think maybe some states are more aware than others, but we've done our best to keep them apprised of this rulemaking. Also another avenue that for EPA to make the public aware of what is happening in terms of the rulemaking process. Each spring and fall, the agency issues the spring or fall regulatory agenda, and it lists the upcoming rulemaking actions, so that the agency either anticipates making or that it will make. And so for all different offices, not only the Office of Water, but the Office of Air and the Office of Solid Waste and Resource Conservation. And so within that fall regulatory agenda, we noted that we anticipated finalizing this rule, and that sometime in the future, I think it might have listed the year 2020 as the date for the second batch of the provisions that were in the proposed rule being finalized. So through those different avenues, we've been trying to keep all the stakeholders that are involved aware of what the agency is attempting.
Now, since the second batch is probably going to be more controversial, are you having any discussions centered on those?
The short answer is that we've really been focusing all of our resources on this first batch. And so once this is finalized and out the door, then we can focus on how best to approach the second batch of provisions. So that we haven't at this time.
Okay. Well, Frank, I really appreciate you being willing to speak to us today. Us being the community of small business environmental assistance programs, many of us are focused just on the Clean Air Act stuff. Some of the states do tend to have a multimedia approach. A lot of times we are not necessarily working with municipalities as much as we are working with individual businesses, usually smaller businesses, but not always. Some of those might involve site visits, but I mean, definitely NPDES does come up, stormwater, at least for me. And then more or less, many businesses that have to get a permit to discharge, maybe to treat their wastewater, then discharge to a city. So we do have some businesses or people who we work with. And I mean, a lot of times it's like, well, you might need a permit, so go apply for one. But we may not really dig that deep in terms of what the permit looks like or how you go about complying with it. Whereas we're probably a little bit more knowledgeable in the other areas.
Well, thank you for having me on. Hope I was able to provide at least some little bit of information that's useful to folks, and I appreciate the opportunity.
Well, I mean, anytime I think we can get someone in with your